transmissão foi iniciada. Bom evento.
Bom dia a todas e a todos. A Escola Superior do Ministério Público, órgão auxiliar e estratégico do Ministério Público de São Paulo na formação e capacitação de seus membros e servidores, em parceria com o Centro de Apoio Operacional Criminal, o CAOCRIM, representado pelo seu secretário executivo aqui presente, Dr. Arthur Lemos Pinto Júnior, secretário especial de Políticas Criminais da Procuradoria-Geral, a quem eu agradeço imensamente pela parceria que temos realizado em diversos eventos e mais esse evento de hoje. Iniciamos o terceiro encontro de uma jornada internacional, tratando com especialistas brasileiros e de outros países, como Espanha, Portugal, Itália, Estados Unidos, a respeito de cooperação jurídica internacional e redes de cooperação. Já tratamos anteriormente da cooperação internacional e compartilhamento de informações no trato da criminalidade transnacional, de lavagem de dinheiro, inteligência, e amanhã ainda teremos um novo encontro para o tema redes de cooperação e confiança mútua. O mundo não conhece fronteiras e a criminalidade organizada está nos vários cantos do planeta, sendo que mais e mais temos que buscar, na experiência de outros países, as melhores práticas para o enfrentamento do que também é uma espécie de pandemia, diante dos efeitos deletérios que gera para a sociedade. São complexos esquemas de lavagem de dinheiro que encobrem e, ao mesmo tempo, financiam a corrupção, o tráfico de drogas, de armas, de pessoas, dentre outros, sendo, sem dúvida, um dos maiores desafios que as autoridades dos diversos países, dos sistemas integrados de polícia, bancários, de controle judiciais, vêm enfrentando. Teremos a oportunidade de conhecer, dentre outras ações cooperativas, as que se realizam na Eurojust, Agência Europeia para a Cooperação Judiciária Penal, e que apoia a coordenação e cooperação judiciária entre autoridades nacionais na luta contra o terrorismo e a criminalidade grave e organizada. Faço um agradecimento inicial ao Dr. Fábio Bechara, que foi o que tornou possível a realização desse evento, que nos aproximou desses diversos palestrantes, para que aqui no Brasil, especialmente em São Paulo, pudéssemos ter qualificadamente o conhecimento de todos eles. Também ao assessor da Escola Superior do Ministério Público, o José Roberto Fumac, promotor de justiça, a doutora Milene Comployer, a quem eu agradeço muito, e em nome deles toda a equipe da escola. Quero aqui anunciar que nesse primeiro bloco de hoje vamos tratar de diversidade entre sistemas jurídicos e harmonização. Pedi e foi aceito a presidência da mesa ao promotor de justiça do Ministério Público de São Paulo, Amaury Chaves Arfelli, um promotor extremamente competente e conhecedor desses sistemas internacionais e que fala muito bem italiano. E por conta disso, Amaury, eu agradeço a sua presença na data de hoje. Também quero aqui fazer um agradecimento em nome de todo o Ministério Público de São Paulo, ao Dr. Filippo Spiezza, membro da Itália, nacional da Itália na Eurojust e vice-presidente da Eurojust. Lamento não falar no seu idioma italiano, mas fica aqui o nosso profundo agradecimento pela disponibilização de seu tempo para trazer ao Ministério Público de São Paulo e principalmente à sociedade brasileira, que também acompanha esse evento, o conhecimento a respeito desses sistemas de cooperação internacional. Então, seja muito bem-vindo ao Ministério Público brasileiro, ao Ministério Público de São Paulo, e desde logo passo a palavra ao doutor Arthur Lemos Pinto Júnior para o prosseguimento do evento. Um bom dia a todos e agradeço a todos aqueles que nos acompanham pelo YouTube nessa manhã tão especial. Obrigado.
Obrigado, doutor Paulo. Eu quero mais uma vez, em nome da Procuradoria-Geral de Justiça, cumprimentar a escola por mais um evento realizado na área penal, na área criminal, um evento que tem um tema bastante interessante, que desperta bastante curiosidade e atenção de todos os promotores criminais e da comunidade jurídica em geral. Então, doutor Paulo, meus parabéns e com certeza será mais um evento de sucesso. Eu agradeço a parceria com o Centro de Apoio e é isso que nos permite avançar no Ministério Público. Doutora Amaury Arfelli, meus cumprimentos, meu amigo pessoal, promotor brilhante, promotor que tem um grande carisma, e quando algum colega quer viajar para a Itália, geralmente procura o doutor Amaury para receber dicas para onde ir, aonde jantar, aonde visitar. O doutor Amaury que dá todas as dicas para vários colegas. Isso não ia ser falado por ninguém, né, Amaury? Mas é importante registrar aí a sua experiência, o seu contato com a Itália, que é muito forte, nós sabemos. Professor Filippo, seja muito bem-vindo. É um prazer poder ouvi-lo e aprender com o senhor, com a sua experiência. Saiba que o Ministério Público de São Paulo é um Ministério Público preocupado com o combate à corrupção, com o desvio do dinheiro público. É um Ministério Público que sabe qual é a sua missão. É um Ministério Público aguerrido, campeão absoluto em recuperação de ativos, campeão absoluto em democratizar o banco dos réus. Não existe outro Ministério Público do nosso tamanho, com a capacidade que nós temos de propor ações penais, obter condenações, afastar corruptos dos seus cargos. Não existe nenhum outro Ministério Público que trabalhe da forma como nós trabalhamos. Então, saiba o senhor está no maior Ministério Público do Brasil, e promotores que gostam e que amam o que faz. A cooperação jurídica internacional é de extrema importância na medida em que, cada vez mais, as pessoas circulam pelo mundo com facilidade. Os negócios são feitos de forma muito rápida. E, da mesma forma, a criminalidade se aproveita de toda essa facilidade para levar a cabo os seus delitos. E, com isso, fica facilitada a prática de crimes e, sobretudo, o envio de valores para fora do país. Então, fica muito difícil obter as informações sobre a prática desses ilícitos. E, para tanto, é necessária a cooperação jurídica internacional. Aí surgem várias dúvidas. Vai ser imposta a nossa soberania nacional para a obtenção das informações ou deverá ser observada a soberania nacional do país que detém as informações? Então, sobre isso, escreve muito bem o Dr. Fábio Bechara, nosso colega, amigo e o padrinho, praticamente o líder desse evento, né? Que foi quem deu o start inicial, o pontapé inicial para esse evento. Então, surgem diversas questões e cada vez mais nós nos deparamos com a necessidade da obtenção dessas informações. Eu me lembro, e falei isso no lançamento deste evento, que um colega de Limeira precisa de informações sobre crimes cometidos por um padre, precisa de informações do Vaticano. Então, no inquérito policial simples, há necessidade de obter informações sobre a remessa de valores para o Uruguai, que hoje é muito fácil de se fazer isso. Em poucos minutos, em 10 minutos, eu transfiro todo o meu dinheiro para o Uruguai através de uma operadora de investimentos. Então, a cooperação jurídica internacional cada vez mais está presente no dia a dia do promotor criminal. Daí a importância, doutor Paulo, da gente estudar e conhecer um pouco do funcionamento, da dinâmica das cooperações jurídicas internacionais e da necessidade do nosso direito penal estar harmonizado com os tratados internacionais e com o direito internacional de uma forma geral. Então, meus parabéns, um bom evento a todos. Eu cumprimento ao professor Filippo, a quem desejo uma boa sorte, uma boa palestra. Estarei aqui ouvindo o senhor com a minha câmera desligada.
Doutora Amaury, o senhor está com a palavra. Bom evento.
Bom dia a todos. Agradeço à Escola Superior do Ministério Público pelo convite. Agradeço aí as palavras do Arthur, suspeito por ser muito meu amigo. E, na verdade, eu posso dizer que eu entendo talvez mais de turismo italiano do que o tema que vai ser abordado nesta manhã. Parabéns pela escola, pelo tema e pela organização, porque hoje nós sabemos que o crime não tem fronteiras, sobretudo os crimes perpetrados por organizações criminosas, sobretudo aquelas ligadas ao tráfico de entorpecente, tráfico de armas, tráfico de pessoas, e também, sobretudo, a prática de lavagem de dinheiro, que temos visto ter uma relação muito estreita com a corrupção no poder público. Esta iniciativa da Escola Superior do Ministério Público vem ao encontro da necessidade que as nações têm de relacionar-se internacionalmente, com o intuito de estreitar os laços entre os países na resolução dos conflitos e nas demandas transnacionais. E um mundo que nós temos uma legislação que não é una, mas as necessidades sociais e culturais são distintas de cada país. O tema da cooperação internacional no combate à corrupção e à lavagem de dinheiro interessa a todos os profissionais do direito, sobretudo os integrantes da Polícia Judiciária, do Ministério Público, da magistratura. Nós temos visto que a legislação brasileira a respeito, e sobretudo a prática das instituições no que concerne a matéria, pode-se dizer que é relativamente nova, necessitando de aprimoramento, de intercâmbio para dar uma efetividade aos mecanismos de cooperação jurídica internacional e compartilhamento de informações. Hoje, o palestrante convidado certamente trará importante colaboração acerca da matéria. Haja vista que a Itália possui, além de uma experiência muito grande no combate ao crime organizado, que tem por trás as tão faladas e conhecidas organizações mafiosas, a Itália também dispõe de mecanismos interessantes, instrumentos legais e processuais relativo ao confisco de bens, sua administração e também recuperação de ativos, que nos interessa conhecer com maior profundidade, principalmente no que concerne também a aplicação desses instrumentos na comunidade europeia. O palestrante de hoje, Dr. Filippo Spiezza, é membro nacional da Itália na Eurojust e vice-presidente deste órgão, da Eurojust. Ele foi promotor de justiça, procuratore da República, por 28 anos, tendo iniciado sua carreira profissional em 1990. Atuou desde 2003 como promotor de justiça contra a máfia, sendo responsável por investigações de crime organizado, lavagem de dinheiro, corrupção, tráfico de entorpecentes, fraude e crime cibernético, inicialmente na Itália e depois como membro adjunto nacional da Itália na Eurojust entre 2008 e 2012, quando se tornou procurador nacional adjunto na Direção Nacional de Antimáfia e Antiterrorismo em Roma, lidando sempre com cooperação judiciária e coordenação das investigações sobre crime organizado e o terrorismo. Ele regressou à Eurojust como membro nacional em 2016, é autor de muitas publicações jurídicas e também atuou na formação de magistrados, lecionou e presidiu grupos de trabalhos e equipes que lidam com análise de questões criminais, legislativas e estratégias com o Conselho da Europa e a Comissão Europeia. Em 2003, recebeu o prêmio Falcone e Borsellino pelo livro O Tráfico e Exploração de Seres Humanos. Repito a todos que a palestra será proferida em inglês, com legendas em português. Então, eu passarei a palavra ao Dr. Filippo. Dr. Filippo, lei potrà iniziare il suo intervento. Buongiorno, con la parola.
O seu microfone está desligado.
Okay. Thank you very much. Thank you very much for your presentation. Buongiorno, good morning, buenos dias. I would like to thank you very much. Thank you, all the organizer, for the invitation to participate to this very important international conference in Brazil. It is for me a reason of a big pleasure to be with you today and to share some ideas, some reflection on the very important topic that you have selected, the diversity between national legal system and the need for harmonization. Indeed, this will give me the opportunity to present some reflection, some practices, and also some ideas that I, of course, take from my personal experience of prosecutor, of a member of Eurojust, and as an Italian national member here in this agency. But it's also a reason of a big pleasure for me to share this moment with you in light of my close link with Brazilian colleagues, as I will explain to you further during my presentation. My contribution, my speech will touch upon the following points. I will talk about the nature of the diversity in the legal system, and why we need the harmonization of the legal system, especially in the field of penal and criminal law and procedural law. Then we'll also make a reference to the experience of the European Union, and I will refer to the adoption of the new cornerstone of the judicial cooperation in the European Union, which is the principle of mutual recognition. Then I will refer to problems and limitations, existing limitations in the harmonization process, and I will try to present some concrete examples, some real cases where the problem of the lack of harmonization can hamper the judicial cooperation procedures. So the context is very complex, and the results of this harmonization are not always very satisfactory. And then I will present to you some concrete example how Eurojust, from our perspective, can tackle such issue and can even present some practical solution for the problems encountered. In case during my presentation you will find the problems in listening or in understanding what I'm saying, please feel free also to interrupt me, because I prefer that our presentation, my presentation, could be interactive as much as possible. So, starting from the title of this conference, or this session, the diversity of a legal system. Why we have diversity? This is quite an intuitive concept. Since the criminal system responds to the principle of legality, which in turn is considered an expression of the state sovereignty, it follows as a consequence that national criminal and procedural legal system present very often legal diversity, even when regulating the same crime, even when they refer to the same procedural investigative measure. In fact, the rules that we have in each national system reflect our constitution, our traditions, our culture. That's why we have such diversity. Although the system, if you look from a broader perspective, tend to converge gradually each other, also as effect of the implementation of international conventions. Such a difference, in my opinion, can be easily found if we make a comparison between legal system inspired by the common law tradition and legal system inspired by the civil law tradition. To remain in the area which is very familiar for me, the area of the European Union legal systems, you can easily refer, for example, to the legal system in Ireland and the United Kingdom, which are an expression of systems jurisdiction based on the principle of the common law, while the majority of EU member states are based on the tradition of civil law, which means they are based on the Romanic and Napoleonic legal tradition. This is reflected on the main principle, which can be found in two different blocks of systems, where in the common law system there is a clear prevalence of the accusatory or adversarial trial principle, while in the civil law system you see the clear prevalence of the inquisitorial principle. And one of the areas where this distinction is made very clear is the area of the evidence, gathering evidence and assessment evidence, the assessment of evidence by the court, by the judge, because it's clear that in the legal system based on the common law, the main need is to ensure the so-called fair trial, processo giusto, while in the legal system, which are based on the adversary trial, on the principle of common law, the aspiration of the trial is to find the truth, scoprire la verità. That's the main results of this consequence. This as far as the diversity of the legal system. The concept of the harmonization is more complex in terms of definition. What is the harmonization? Do we have in the EU legal system a specific provision which defines the concept of the harmonization? There is no one single provision in the Lisbon Treaty and the other EU legal text which define the concept of the harmonization. Nevertheless, the concept of harmonization is understood, is included in many provisions of although we don't have a definition of what the harmonization is. And in the Lisbon Treaty, which was adopted and which entered into force in 2009, we had a clear reference to the harmonization in the field of criminal law and procedural law, even stronger than the concept which was included in the previous EU treaty, the Amsterdam Treaty of 1997. This is true for procedural law, and this is also true for criminal law, where the European Union, by means of directives, can establish the essential elements for crimes and sanctions in case which have transnational dimension. And furthermore, we have an important novelty in the Lisbon Treaty, because the harmonization of criminal provisions is something that should be achieved by the EU legislator, irrespective of the need of judicial cooperation process. While in the Amsterdam Treaty, the harmonization was mainly instrumental to the judicial cooperation process, Now the harmonization of the criminal law in the European Union is an autonomous value, is an autonomous target of the EU legislator. But why we need harmonization? We need harmonization at the international law and of course at EU law. The need for harmonization is not new in the history of the European legislation. The first example of the harmonization can be found in the provision of the Convention for the Protection of the Financial Interest of the European Union, which dates back to 1995, la Convenzione per la protezione degli interessi finanziari. In the area of criminal law, this represented the first concrete example of the harmonization in the field of the criminal law. But why we need harmonization? Again, the question arises, why do we need such harmonization? We need to start from the, I would say, from the phenomenal side, because we are witnessing the overcoming of national borders, not only by the lawful and legal conduct and the exchange on the legal market, but also by the illegal organizations. Over the past decades, the criminality has assumed as a main recurrent feature some specific characteristics. The criminality more and more is acting in associated form and is having a transnational dimension. These two features can be easily seen and perceived by our perspective, by EU perspective, like Eurojust does. In my experience, I can testify that the most serious forms of crimes present such dimension, an associated form associativa, and also this transnational dimension. Therefore, we need harmonization, first of all, for a question of having common legal value in different member states, in different domestic legislations. The harmonization has the objective to ensure an homogeneous legal treatment of criminal behavior in different jurisdictions, respond to the need to have homogeneous reaction from the jurisdiction, from the states in respect to the same violation. It helps to create, first of all, a common sense of justice that would be compromised by several differences in the legal system among the different jurisdictions. And directly connected to this need to have a common value in the criminal system, there is the additional need to avoid form shopping phenomena that could be realized in case of transnational crimes. Indeed, the criminal groups are very smart and able to exploit the difference of jurisdictions, the differences of the criminal system, and they knowingly move themselves. They can move to jurisdictions where the reaction of the state of the jurisdiction is weaker, and they position their criminal activity in the weakest jurisdiction. I can refer immediately to a concrete example, which is the result of a project that we have just finished at Eurojust. We started a reflection on the basis of our operational cases on so-called sham marriage in the case of irregular migration cases, where we have found that criminal networks deliberately started their criminal activities in jurisdiction where the sham marriage is not criminalized, because not all the legal system, not all EU member states foreseen criminal sanction for the case where the marriage is made only by convenience, only in order to create the conditions to overcome and to fulfill the legal requirements for a legal entry in other member states. Then, on the basis of this need to have common values in different jurisdictions, we have had over the years, several directives, several framework decisions, several legal acts in order to harmonize the legal system, the criminal law in different member states. You have to consider, for example, the framework decision of 2000 for the harmonization of the legislation containing criminal sanctions for the counterfeiting of a currency, of the euro. Then the framework decision of 2001 on money laundering. Then the framework decision of 2002 for the fight against terrorism. Then the framework decision of 2002 on traffic of human beings, and so forth and so on. So we can refer to several legal instruments adopted by the EU legislator in order to achieve such important objective, which is the harmonization of the criminal legislation in the EU member states. This process has continued also after the entry into force of the Lisbon Treaty, and as I said before, the process has been reinforced by a new legal framework because of the overcoming of the previous distinction in pillars. So we now use for the criminal law the same legislative procedure that was adopted for the civil law. But there is another reason why we need the harmonization of national legislations, which is directly related to the functioning of the judicial cooperation instruments. Indeed, the existence of significant divergences in the criminal law may not only determine inequalities of legal treatment and fuel the so-called form shopping phenomena, but can also affect the functioning of a judicial cooperation mechanism, especially where such mechanisms require compliance with the principle of double criminality. You know better than me that there is a standard clause commonly included in the extradition agreements. This implies that the alleged crime for which extradition is sought must be classified as a crime in both the requesting and the requested extradition country, although the requirement is commonly interpreted as referring to the offense in question by nature, irrespective of the legal denomination or classification of the offenses concerned. Over the time, at least at the level of the European Union, the principle of double criminality has been subject to the progressive nuances in order to reduce its scope and its impact on the judicial cooperation procedures. So you have example of other international conventions, like the European Convention on Extradition of 1957, where the convention tried to limit the impact of such clause and allow the extraditions of offenses which present a certain gravity, the same penalty from the side of the extraditing member states and the requested member state. But it is important to underline that the dual criminality requirement is not only making sometimes very difficult to apply, to implement judicial cooperation procedure for extradition, but also judicial cooperation for legal assistance, judicial cooperation procedure in order to obtain evidence, because according to the convention, at least at the European level, but this is also true, is a sort of general trend that can be seen also in other international conventions. The dual criminality is often required for the most intrusive measures. Think about, for example, search and or interceptions. In order to obtain legal assistance from the foreign jurisdiction for these most intrusive measures, you need to prove that you are proceeding for a crime which is also foreseen in the foreign jurisdiction. So again, the lack of harmonization in respect to the criminal law can have a big impact, a heavy impact on the implementation and on the success of judicial cooperation procedure. That's why at the European Union level, the legislator decide to change the perspective, to change the approach. The perspective of a criminal, an harmonization of justice and criminal legal systems was considered very challenging due to the different legal traditions that we have, as I mentioned before, between system inspired by the common law tradition and system inspired by the civil law tradition. Therefore, in 1999, the Council of the European Union decided to set the stone for a new approach to the judicial cooperation procedure, and the very tremendous change was to devise a new principle. The principle which was experimented, was successfully implemented in the civil matter, which is the principle on mutual recognition of judicial decisions. It means that a judicial decision adopted by a foreign judicial authority should be recognized and should have effect in other jurisdictions as it was a sort of judicial decision adopted by the foreign authority. Although the legal system, although the criminal provisions could be different in a concrete case. But very soon, the legislator realized that a system based on the principle of mutual recognition cannot work alone without a good harmonization of legislations. Then, in addition to the principle of mutual recognition, it was considered necessary to continue the harmonization of procedural criminal law, because this built up the precondition in order to make the principle of mutual recognition effective and functioning at the European level. In order to give you a concrete example of what I'm talking about, I can refer to the first expression, the first instance of a mutual recognition principle in the European Union, which is the framework decision on European arrest warrant. The European arrest warrant is an instrument which tend to replace the traditional extradition procedure. The main novelties of the European arrest warrant are the direct contact between judicial cooperation procedure, so you don't have the filter of the political authority that you have in the request for extradition according to international legal treaty. You have the reduction of dual criminality requirement, because we have a list of 32 offenses for which, if the European arrest warrant is issued by a judicial authority in relation to one of the crimes listed in these 32 crimes, the judicial authority who received the European arrest warrant should execute the European arrest warrant without a check on the dual criminality. Therefore, you have a reduction of grounds for refusing the execution of European arrest warrant, and in general terms, you have a simplification of the procedure. As a result, I can refer that more than 150,000 European arrest warrants have been issued at EU level until 2019, where in terms of duration of the procedure, generally speaking, a procedure for executing the surrender of a people subject to an European arrest warrant can vary from 2 to 3 months, in case there is a lack of a consensus from the surrendered person to be surrendered. And this is a clear advantage if you compare the European arrest warrant procedure to the ordinary terms which is needed for the extradition procedure. Normally, you know, also according to your experience, that we need more than 1 year to have the extradition of a citizen from one jurisdiction to another jurisdiction. And this is the reason why, if we look to the history of the European arrest warrant legislation, we can see that this is a clear successful story in EU legislation. But although this improvement, also in the field of European arrest warrant, we are experimenting a lot of problems, legal problems and practical problems that we see, I would say, with much clarity from Eurojust perspective. I will refer immediately to a concrete example, which is quite frequent in our cooperation, for example, with Germany. Sometimes my colleagues in Italy issue the preliminary judge issue an European arrest warrant for the crime of a criminal association, participation in criminal association, or for the crime of a mafia type association, like mafia, 'ndrangheta, Camorra, and other criminal associations operating in Italy, which are quite famous also, I assume, in your jurisdiction, because we are speaking about criminal organization, very powerful criminal organization, worldwide criminal organizations. What happens very often is that the court, the competent German court, which received the European arrest warrant and is required to execute the arrest warrant, start asking information about the legal provision, about the crime, because they don't understand at the beginning which type of charge, which type of accusation has been included in the European arrest warrant, especially when the Italian prosecutor are proceeding only for the participation in criminal association without any references to criminal aims, without making reference to other criminal activities like international drug trafficking or money laundering or robberies or other crimes. So especially solely when you have the accusation of criminal organization, it happens that the German court don't understand which is the crime for which you are seeking the extradition of the people. And you see that the participation in criminal organization is one of the 32 offenses which is included in the list for which the executing authority should not check the dual criminality requirement. Why this happens? Because, of course, the judge would be sure that there is a sufficient threshold of evidence supporting the accusation. And then from the side of the evidence, they move the attention to the crime. They don't understand the crime, the accusation, simply because they have in their legal system a different typology of the crime of criminal association. And you see in this example how the differences between the legislation in Italy and legislation in Germany concerning the crime of criminal association can hamper a judicial procedure like the European arrest warrant surrender, although we are speaking about judicial cooperation instruments based on the principle of mutual recognition. Therefore, the reference to the principle of mutual recognition is not solving at all the questions, but still problems remain in place, and still the harmonization of criminal legislation is fundamental in order to ensure the correct application of the judicial cooperation procedure at international level. The existence of legislative differences concerning not only the criminal law or the legal provisions related to crimes and then sanctions, but differences are relevant and can hamper the judicial cooperation procedure also in relation to the criminal procedural law. Also, differences in the procedural system can have a big impact on the success of our procedures. To remain at the EU level, I want to refer to another concrete example. But first, before introducing such example, I need to inform you about another important legal instrument that we have at the European Union level, which was introduced in 2014. I'm referring to the European Investigation Order, Ordine di Indagine Europeo. What is the European Investigation Order? It's another example of a judicial cooperation instrument based on the principle of mutual recognition, which was introduced in 1999 at the Tampere Council. I already have explained what are the main features of the mutual recognition principle. And I mentioned already the European arrest warrant as concrete example of the application of such principle to the matter of the extradition. Now, with the European Investigation Order, the principle was for the first time implemented at EU level in the field to the field of the evidence, to gathering evidence. So you can see that after 15 years, because this measure was only introduced in 2014, for the first time, the European legislator decided to offer to practitioners, to prosecutors and judges, a new judicial cooperation tool based on such principle of mutual recognition. With this attempt, the legislator has tried to simplify all the system, because the European Investigation Order is a general instrument that can be used for any type of evidence that you need in other foreign jurisdiction. So the European Investigation Order is currently the tool that we use for any cross-border need of evidence abroad. And this is meant to replace the traditional legal request for judicial assistance, the LOR, based on the international legal treaties. Although such important innovation, we see again how the differences in the procedural system can represent a big obstacle to the effectiveness of judicial cooperation procedure. And now the example. One of the most sought measures from our colleagues, especially in Italy, is the interception, bug interception with a device put in a car, especially in case of international drug trafficking, where we start such interception in Italy, but the car is driven in other jurisdiction because, for example, the driver, the target, the suspect is going to meet other members of the criminal organization, for example, in the Netherlands, in Germany, he's going to meet his accomplices for buying the drug, or just for buying arms and for other illegal activity. What is foreseen in the European Investigation Order Directive, in the law, is foreseen that if I start an interception in Italy, and then the car, which now I am intercepted, is moving in other jurisdiction, and technically speaking, I don't need the assistance of foreign colleagues because I am able, from a technical point of view, to intercept the car, thanks to the technology, I have to notify anyway to the foreign authority an information through a specific format, it's called Annex C, that I am intercepting this car, I have the bug car, and the car is moving in the foreign jurisdiction. So just a notification of an information. German legislator, Dutch legislator, the same in Belgium, they have implemented this directive in a different way. They apply the provision of the European Investigation Order Directive only for telephone interception, not, for example, for bug interception, per le intercettazioni ambientali. This means that if I have to continue my technical investigation and try to follow the suspect who is moving in another jurisdiction, according to the German colleagues, I need to issue another type of judicial decision, and they require, they ask the issuing of this judicial decision a request for the authorization of this technical interception before the car cross the German border. You see, in such situation, I already got the authorization from the Italian judge to make interception, but for a different legislation that we have in Germany, I need to have also the authorization from the German judge, and this is okay. But the German court required that I ask the permission of the German judge before the car crossed the borders. If sometimes it's possible, because the police got information of the moving of the trip of the car before the car entered the German territory, sometimes this is not possible because they are crossing over the night, they immediately cross the borders, and in situation like this, the German court rejected the Italian request and they refused to authorize the continuation of interception. And sometimes we lose important evidence that have been gathered through interception. For example, interception which proved, for example, further illicit criminal activity, even a situation where we have the evidence of a murder inside the car, we run the risk to lose the evidence in situation as described above. This means that the harmonization is a fundamental requirement which is always important. Although we are applying, we are moving, we are referring to legal system, like we have now at the European level, which are inspired by the principle of mutual recognition. But you can ask to me now, but Filippo, why we have such a situation if you have a directive of the EU legislator which clearly set the guidelines to have such harmonization? Because again, the legal provisions set by the EU legislator are directives. Directives, by definition, leave a discretion to the national legislator on how to implement, how to regulate at the national level. So you have at the EU level only the minimum rules, the fundamental guidelines in terms of a provision for crimes and provision for investigative measures. But the details of the legislation, the details of the regulation is left to the national legislators. And in this implementation phase, sometimes the legislators, in order to fulfill with the legal traditions and with the constitutional principle, they transpose the directive in a different way. Of course, we have also remedy for such situation. In the Lisbon Treaty, according to the current legal framework, the European Commission now has the power to check how the member states have transposed the EU legislation, and also to start the so-called infringement action, which is an action towards the member states who is considered responsible for not having transposed in a correct way the EU legislation. But this is a long process, and during this process, in the meantime, the prosecutors can remain without the necessary tool to complete the investigations and to conduct their procedure in a successful way. Another example, a very fresh example of this morning. We are conducting an investigation for mafia type association. Again, two jurisdictions involved are the Italian jurisdiction and the German jurisdiction. There is a proposal to create a joint investigation team. I will talk to you about the joint investigation team. What is relevant in this context is the fact that one of the proposals from the German and the Italian prosecutors is to set up an undercover operation, operazione sotto copertura. Now, what is happening is that we are having legal problems in order to deploy an undercover agent between Germany and Italy. Why? Because according to the German procedural law, the undercover agent can never testify in front of the court, either in front of the German court and in front of the Italian court, because the undercover agent, according to the German legislation, is always completely protected. He has only the duty, the undercover agent, to make a report to the leader of the team, the investigative team. Then only the leader can testify in front of the court during the trial. In Italy, the undercover agent is protected by the law. Never you can ask in front of the court which are the real details, personal details of the undercover agent, but the undercover agent has the duty to be present in front of the court, although some measures and protection, but the evidence should be presented in front of the court. So this means that a German undercover who will come in the Italian territory and make some important operation and gather the evidence, the proof of important criminal fact, cannot make any witness, any testimony in front of the Italian court. And this is a problem deriving exactly from the discrepancies between the German legislator and the Italian legislator. And I can present to you hundreds of a concrete example of the impact of different legislation. And you can easily understand that the more we refer in terms of array of jurisdiction, the more international is the context, more problems we can have when we are working with our counterparts, for example, with the Brazilian colleagues in relation to investigations for serious crime. This is depending not only by the quality of the implementation by national legislators. I have mentioned the fact that the legislator in member states sometimes transpose in a not completely, I would say, loyal way the directive or the EU legislation. This is depending also by, I would say, imminent and natural limits in the harmonization process. First of all, the need to respect fundamental principle. This require a critical verification of the different legal definition EU member states and the necessity to ensure that the legislation is always compliant with the individual guarantees and with the fundamental principle. This is a situation, a condition particularly emphasized by the new Lisbon Treaty, which in the Article 6 make a direct reference to the validity of the Charter of Fundamental Rights of the European Union, foreseeing the accession of the European Union to the European Convention on Human Rights, and identify as a general principle of the Union law the fundamental rights as guaranteed by the Convention on Human Rights. So the need to respect human rights and fundamental principles can necessarily create distinctions and differences in the implementation process at the national level. And another regulatory limit to the harmonization process can be found in the fact that the competence of the European Union in the criminal field must be exercised in accordance with the principle of subsidiarity and proportionality, always taking into account the legal traditions of member states. So you see that it's really a difficult balance when you try to have this harmonized legislation in different member states or in different states in general terms, because you have to ensure some common provisions, but you cannot neglect, you cannot overcome fundamental principle and the legal traditions that you have in single domestic jurisdiction. Therefore, the question arises, how we can work and how we can ensure a successful cooperation, having in mind all the limitations deriving from the lack of a complete harmonization process. The harmonization process will continue, will receive new impetus from the international conventions, and in my opinion, another important legal international reference are the UN conventions, the UNTOC conventions, la Convenzione contro il crimine transnazionale di Palermo of 2000, which in this respect play a very important role. Such convention, which represent the most global international legal instruments in order to combat any form of transnational crimes, and which proves to be also a very modern convention, because some provisions still present a big potentiality in their application. And I will also make a reference specifically to an example of cooperation between Italy and Brazil as an example of a concrete application of the UN Convention of 2000 against organized crime. But another important role in this difficult situation, especially for practitioners, is the role of regional agency network association of prosecutors and practitioners. In this respect, allow me to refer to the role of Eurojust, which play a fundamental, it's a fundamental subject, a fundamental actor in relation to this contest, because at Eurojust, we try to follow a very pragmatic and practical approach in order to prevent problems deriving from this situation which I have described, and also to find solution ex post after problems are presented by prosecutors. I'm not sure that all the colleagues and all the academics and people listening to this conference are familiar with the Eurojust. Therefore, allow me just to make a reference, some basic reference to our agency. Eurojust was created in 2002. It was one of the main novelties brought about by the Council Tampere, which I mentioned before, which introduced the principle of mutual recognition. This European body was created in 2002 with the specific aim to strengthen the judicial cooperation procedures among the EU prosecutors, the judicial authorities of EU member states for serious crime having cross-border dimension. So the main mission of Eurojust is to facilitate the judicial cooperation procedures for serious crime and the transborder dimension, and to ensure to support the coordination of investigations for crime affecting two or more member states, or one member state and another third country. The essence of Eurojust is completely different from other networks. We had already in the previous experience the liaison magistrate. We had already the European Judicial Network, composed by the contact points, by magistrates, prosecutors active in different member states and link each other in this network. Why Eurojust is different? Because for the first time, the EU legislator decided to set the basis for having a EU body where all the national representatives are sitting together in order to share information, in order to discuss about operational cases in order to devise investigative strategies to be more effective against any form of cross-border crime. That's why we have a premises, we have an headquarters in The Hague, in the Netherlands, where I'm speaking about, and we work all together in order to present operational cases on the basis of the need and the request of our national authorities. In 2019, Eurojust has become an European agency. This means that we have increased the EU spirit, the EU dimension, and we have lost a little bit the so-called intergovernmental dimensions. Therefore, I am Italian representative, but I am here at Eurojust not for protecting the Italian interests, but in order to pursue the European dimension. The EU interest means that I'm going to deal in a case in order to ensure equal satisfaction of my colleagues in Italy and also other colleagues from other EU member states. Another important novelty of the new Eurojust regulation, which was adopted in 2017 and entered into force in 2019, is that Eurojust now can take also the lead. Eurojust can play a proactive role in order to propose a new investigative path to national authorities on the basis of the information that we analyze or the information that we receive by other agencies. Yesterday, working with my colleague, Angela Contenisio, who is sitting beside me, we received an early warning notification from Europol about an incident of immigration occurred on the Adriatic shore. I immediately contacted the prosecutor in Lecce, which is a city in the south of Italy on the Adriatic coast, in order to know if there were any sort of investigations linked to such incident concerning transporting of migrants from Albania to Italy. And then we discovered that there was no already open investigation in Italy. Therefore, on the basis of the information received by Europol, I triggered, using my legal prerogatives, the opening of an investigation in Italy, on the basis of which I was even able to share further information with Germany and Austria, because the entities of the Italian investigation, and particularly the phone numbers of the smugglers, resulted as well also in a German investigation and in Austrian investigations. You see from this concrete example how important could be the role of actors or agencies operating at supranational level when they become a hub of information, when they are able to collect all the information, to cross and match the information, and to propose not only to receive passively requests from the national authorities, but also to be more proactive and to trigger new investigations. The story of Eurojust is a good story at European level, and I'm proud to be part of this community, and also allow me to express my personal satisfaction and for the privilege to be vice president of this agency. I try to make in my daily effort for the growing of the agency a very tailor-made operational dimension. Eurojust in the past probably did have the same approach and the same dimension. Now we have become a more operational agency, a hub of judicial information, able to connect in real time all the national authorities in EU member states and to provide an added value to the national investigations. But it is important also from your perspective to understand that we go well beyond the EU borders in our actions. According to the legal framework, Eurojust has been able to conclude cooperation agreements with third countries. We have cooperation agreements with several countries, with Western Balkan countries, with the United States of America, We have cooperation agreement with Switzerland, with Norway, with Macedonia, with Albania, with Norwegia, with Ukraine, with Montenegro, and the majority of the states I've just mentioned have seconded the magistrate at Eurojust. Therefore, we have here in the same premises working together the liaison magistrate from Ukraine, the magistrate from Albania, the magistrate from Macedonia, from Montenegro, and in a very fast and efficient way, we can approach each other, we can discuss about practical problems, even problems deriving exactly from the question of the issue that we have considered today of the lack of incomplete harmonization of our national legal systems. Indeed, how we tackle this problem here is, first of all, from a practical perspective. When we have problems like I mentioned before, the need to display an undercover agent in different jurisdiction or interception in different jurisdiction where the legal regime is different, we invite our colleagues before sending the formal request to refer the case to us in order to discuss in a preventive way with our counterparts and to find a possible practical solution before any formal request is launched. So I think this is a good practice that can be shared with you, and you can probably already have in place in your system. That is important, a constant dialogue, a constant talk with your partners, with your colleagues, before any formal legal request is transmitted to the counterparts, is necessary to verify if all the legal requirements are met and if the request can be satisfied. And in case, so sometimes we find also creative solution. In the example that I have presented already, the undercover agent, we have considered that we can overcome the legal obstacles in this way, that when a German undercover agent come to Italy, enter the Italian borders, automatically from the Italian prosecutor perspective, they will deploy another undercover agent. So the Italian undercover agent will work together with the German undercover agent. They will work together and they will make also the same, I would say, investigative activity. This means that if the German undercover agent will be prevented from testifying in front of the Italian court, the same will not apply to the Italian undercover agent. But you can do this only because you have prevented the problem and you have put in place a practical solution in order to find a possibility to act observing, respecting, full respecting the legal legislation in Italy and Germany. Another, in my opinion, concrete judicial cooperation tool where such preventive exchange of information, legal information, can be easily achieved is the joint investigation team. The joint investigation team, the concept of the joint investigation team is quite simple. Is a team, is a group, è un gruppo of prosecutors and law enforcement authorities working together in order to achieve a specific aim, specific objective in a limited period of time in relation to specific investigations. When you have investigations to be carried out in Italy or in Germany, in the Netherlands, in other foreign jurisdiction, instead of sending letter of request, instead of sending out requests based on the judicial cooperation instrument like the European Investigation Order I mentioned before, you can decide, if there are all the conditions, of course, to set up, to create a joint investigation team, squadra investigativa comune. The joint investigation team is foreseen by the EU legislation. The joint investigation team is strongly supported by Eurojust. The setting up procedure foresees the stipulation of an agreement. You have a formal agreement where the parties are included in the purposes of the joint investigation team, the duration, the content, and the objectives, the investigative measures which will be implemented, will be carried out during the joint investigation team. Why is important this formal agreement? It is important because when you are considering to implement, to carry out a specific investigative measure, at this stage, very preliminary stage, you can already understand and know which will be the legal requirements in the jurisdictions involved. And then you can also try to prevent the legal problems which will be encountered by the operators, by the law enforcement authorities. And then you can regulate all the aspects in the cooperation agreement, in the agreement, nel contratto, in the agreement of the JIT, you will regulate the specific aspect in order to prevent that the legal problems arising and deriving from the diversity of the legal system can hamper the functioning of the joint investigation team. What is very interesting from your perspective is that the possibility to set up joint investigation team is something which is included also in the international conventions, like UN Convention Against Transnational Organized Crime, the UNTOC Convention, la Convenzione di Palermo, because according to Article 19 of the UN Convention, there is the possibility to stipulate specific agreements between the state parties in order to conclude joint common investigative group. And the beauty of this provision is that it's interpreted in the sense that it can be implemented, although you cannot have in your domestic legislation at national level specific references in your procedural code to the joint investigation team. I would like to take the opportunity of this conference to thank del Ministero Pubblico della Confederazione degli Stati Brasiliani for the support that was given to us, specifically to Italy, in setting up the first ever joint investigation team between Italy and Brazil in a very serious investigation for serious crime, for mafia type crime. Of course, the investigation is ongoing, and I cannot mention and I cannot discover any details of such joint investigation team. But the JIT is working, the joint investigation team is working. We have faced in a preliminary stage many legal issues, even concerning the signing process, the ratification of such agreement. But after 4 or 5 months of very hard work, we managed to conclude this cooperation agreement. And I'm proud of this because the satisfaction of our national authorities is very high. They are taking a lot of benefit from this joint investigation team. And I took the opportunity of another important fora of the UNODC. The last working group meeting was held in September, 2 weeks ago in Vienna, to relaunch the idea of working in a joint investigation team also in relation to another important crime area, which is smuggling of migrants. Smuggling of migrants is another concrete example where the use of joint investigation team is recommended. The big advantage of a joint investigation team is that when you set up a JIT, you don't need to formally send a letter of request, a rogatory letter to foreign authorities in order to gather evidence. You can exchange all the information and the evidence inside the JIT, within the JIT, with your partners in real time. This means that the model, this judicial cooperation tool is particularly useful in a context where you are investigating a crime where you need a real-time investigations, a real-time exchange with your partners. And this happens for most of the serious transborder crimes we are dealing with at Eurojust. We are not dealing for simple crime where you simply need to gather, for example, the testimony, the evidence of someone in other jurisdiction, but you need to follow the crimes. You need to follow the evolution of the criminal group, and then you need to be very active and capable to respond in an efficient way to the criminal organizations. I would like to conclude my presentation saying that the evolution of the judicial cooperation's instruments is very promising, in my view. Thanks to the EU legislator, thanks to the international organizations, now we are moving in a different era where the principle of the solidarity, the principle of cooperations are prevailing. In the past, not always it was like that. In the past, we gave prevalence to the principle of sovereignty, to our traditions, to our national approach, which is good to some extent. In a worldwide and globalized world like the world where we are living now, where we are facing the challenge of the organized crime, of the terrorism, of the international drug trafficking, of the cybercrime, we need to be efficient. We need to be very organized like criminals are. And that's why I think that one of the big hope of Giovanni Falcone, the judge who was assassinated by the mafia, and to whom we have dedicated our office at the Eurojust. This office is devoted to the memory of Giovanni Falcone and Paolo Borsellino. I think that now the memory of these two Italian, and I would say not only Italian, but worldwide heroes rest on a good hope, rest on the hope that their dream is coming true. Their dream is becoming a reality. The dream where all the prosecutors, all the judges feel to be part of a whole community, a unique community where they feel free to exchange their practice, their views, their traditions, and also their procedures. Thank you very much for your attention.
Allora, agradecemos a palestra do professor e doutor Filipe Spienza. Nós temos aqui algumas perguntas e eu vou fazê-las ao doutor Spienza. Dottor Filippo, abbiamo delle domande. La prima domanda vogliono sapere se c'è la possibilità di accordi isolati tra i Paesi membri della Comunità Europea e se questo è possibile deve avere la concordanza, l'approvazione della Comunità Europea. Lei per cortesia deve rispondere in inglese.
Okay, I'm not sure if I completely got the question, because when you refer to accordi, agreements, are you referring to operational agreements? Accordi operativi?
Cooperazioni, sì, accordi di cooperazione.
Okay. No, there is no need to have the approval of EU authorities. If you're referring specifically to operational agreement for setting up joint investigation team, we have the EU legal framework, and then we have national legislations. In Italian legislations, the formal decision to approve such agreement belongs to the prosecutor, to the chief prosecutor, al capo procuratore. In other jurisdictions, we can have different legal requirements. For example, again, just to mention, in Germany, the agreement should be approved by the at the federal level, but by the federal authority. They make only a sort of formal check for the merit the decision belongs again to the prosecutor. In other jurisdictions, like in Italy, the decision belongs to the prosecutor responsible of the case, responsible for the investigation. So the answer is that there is no need, there is no formal approbation at all from at EU level. There is a formal decision to be taken at the national level by the chief prosecutor in the majority of cases. In some jurisdictions, it also requested the approval from the central authority, sometimes from the Minister of Justice. But in this case, the approval for the Minister of Justice is merely formal approval, which does interfere with the merit of the agreement. And I would also like to mention that from the Eurojust perspective, we can be formally part of the JIT. I am a JIT member, JIT participant, for example, in the JIT between Italy and Brazil, where my colleagues are the members and I'm a participant in terms of the advisor of the joint investigation team, supporting the work of joint investigation team, supporting the coordination of the work of the investigations of the members. And then there is another important function of Eurojust. This is a specificity of Eurojust, our organization. We can support from financial point of view. We can fund the joint investigation team because the joint investigation team, I love to say that the joint investigation team can be considered for the efficiency of the tool like the Ferrari, la Ferrari della cooperazione. But like the Ferrari, the joint investigation team requires resources because you need to organize trips of law enforcement authorities of the police from one jurisdiction to another jurisdiction. You need to, sometimes you need interpreters, you need to devise technical tools. So these require financial resources, and the Eurojust support the functioning of a judicial cooperation tool also with a specific dedicated fund.
Ok, grazie. C'è un'altra domanda da Daniel Fernando Secomandi. Lui vuole sapere se lei vede qualche somiglianza tra le operazioni Mani Puliti e l'operazione Lava Jato in Brasile. E anche lui chiede se dopo le operazioni Mani Puliti in Italia il sistema legislativo italiano ha migliorato, ha subito delle riforme interessanti a livello del combate al crimine organizzato.
This is, of course, a question more related to criminological aspects of the, especially of the previous investigative experience in Italy. In relation to the first part of the question, I not aware of many details concerning the operazione in Brazil, but for sure there are some similarities with the operazione Mani Pulite. The operazione Mani Pulite was possible thanks to the novelty introduced by the Italian criminal procedural law, the reinforcement of the prosecutorial activity and their prerogatives in the criminal procedure, but also because the system reached a level, very high level of corruption, where the corruption, the illegal funds of the political parties reached a threshold very high. That's why it was quite, I would say, inevitable to have such reaction from the judiciary. At that time, I remember, was public prosecutor in Salerno, And I remember I investigated quite for a long time public officials, high-level officials concerning the academy in Salerno. And then I remember that there was no one single public tender where the bribe was not paid. Almost all the public tenders were affected by corruption. So the level of corruption was to some extension, to such extension that was quite inevitable to have judicial reaction. And then in the system unveiled a lot of bribes paid by public officials, by politicians, and also, you know, probably better than me, that there was a reaction also during the immediate aftermath of this important age, with some say counter-reform, some reaction from the legislation where there were introduced some important limitations. For example, I cannot forget the changes in the commercial law concerning for example, the reformation of the crime of bankruptcy, the corruption among private. There were some changes in the Italian legislation which were not much appreciated by prosecutors and by ordinary people. But then again, in 2012, we had a new important reform, a new important legislation concerning the crimes against corruption. And this process was reinforced even by the recent government. So what you can see from a general, broader perspective is that it is always important that any judicial or prosecutorial action is accompanied and supported by the society and by the important legislation process. Otherwise, the judiciary cannot be the only answer, the only solutions to this serious problem affecting the modern society. We need to proceed in a balanced way to have a good and fair procedure at the criminal level, supported by the right reformation process at the political level and at the administrative level. I don't know if I answer the question, but this is my perception, of course, in relation to this.
Sì, perfetto. Allora, abbiamo un'altra domanda che viene da Eliton Cardoso. Lui vuole sapere se tra Brasile e Italia quali sono le maggiori difficoltà per quanto riguarda la cooperazione, all'indagine contro corruzione e lavaggio di denaro.
The main difficulties, in my opinion, are linked to the fact that these criminal phenomena require a very, I would say, modern approach, in terms that there is a need for almost simultaneous investigations in both jurisdictions. If you have a crime in Italy of corruption or in Brazil, and then you have also to follow the money and to investigate the money laundering activities, there is a need that these type of investigations can proceed in a very efficient and fast way, because of the risk that the procedural crime can be high, they can be transferred to fiscal heaven, to criminal heaven, and then they simply disappear. This is a question arising not only in relation to cooperation between Italy and Brazil, but is a more general question for all the investigation concerning this type of crimes, because this is exactly an area where, if you look to the legal framework, if you look to the hard law and soft law, you can see that we have a very complete, a very big and extensive legislation in place at international level, at national level. You have a lot of organizations who pay attention to the money laundering activity and to soft law production in this specific crime area. Where we see deficiencies is in the implementation of such legislation. And why this? Because such investigations are complex, require resources, require to have centralized information concerning bank accounts, properties, immovable goods, movable goods, and the exchange of information in an efficient way. Sometimes the information circulates, sometimes the information is transmitted, other times the information it's quite difficult because of the blockage of the formalities, the legal requirements. That's why when I said the judicial cooperation tools based on the legal request are, of course, the traditional way to deal with such cross-border crimes. But if you consider all the formalities, all the time, which is requested to go through the central authority and then to be transmitted to diplomatic channel, central authority, and then to the prosecutor who should execute, and then you have also the remedy at the national level. Sometimes, according to national legislation, the suspect has the right to lodge an appeal against the evidence when the evidence have been found. All this is clearly an obstacle for an efficient cooperation. We need to move from this, I would say, traditional way to approach such system, traditional form of cooperate, to a modern form of cooperate, where we should be able to exchange information in a more fast and efficient way. It's in another good condition is to have a good combination of law enforcement cooperation, police cooperation, and judicial cooperation. Sometimes the police cooperation is able to exchange information at police enforcement level, and then you have to couple and complement the cooperation at the judicial level in order to gather the evidence. It's a question of goodwill. It's a question of a good legislation in place, but it's a question also to be, in my opinion, also creative, not to block ourselves in front of the obstacles, to take the challenge and to find sometimes also creative solution in order to overcome the obstacles by respecting the legislation, by respecting the principle, by respecting the guarantees, but try to always to reach the final results.
Ok, grazie. Lasciami controllare se ci sono altre domande. Allora, non havendo più domande, não tendo mais perguntas, eu, aos nossos assistentes, aqueles que assistiram à brilhante exposição do Dr. Filippo, eu peço que dedique um tempo para o preenchimento das questões de opinião sobre o evento da Escola Superior do Ministério Público. Allora,
Mauro, se mi consenti,
sì,
vorrei solo fare
prego.
un riferimento. If you allow me, just make a final reference, not because I want to publicize or advertise my outputs, but just because it's an opportunity for me to share some experience with you. Because take into account my experience here at Eurojust as vice president for 2 years and my long-standing experience in the field of cooperation, I have decided to elaborate a written book on the international themes concerning the situation in Europe. And the last week, a new book was released. It's called Attacco all'Europa. It's just a compendium of the main criminal threats affecting European Union. I consider the threats coming from the terrorism, from organized crime, traffic of human beings, smuggling of migrants, and cybercrime. And it could be interesting, I don't know, for the audience, if they wish, to have a look to this book where I presented also figures, data, because I think that we need to approach such topics with a rational approach and not with an emotional approach, starting from the data, from the facts. And then I have analyzed also the answer that we have put in place. Of course, as a practitioner and also a member of this management board, I'm not completely satisfied of the answer that we have put in place so far. That's why I also took the responsibility to indicate possible solutions to the current gaps that I still see in the system. And I think that then will be the responsibility of politicians to consider such proposal in order to fill the gap and to complete the systems. But this represents, I would say, the result of a long effort from my side. So I'm really happy that I have the opportunity to share with you also this experience through this book that I put to your attention, Attacco all'Europa. Thank you very much, and sorry for making this reference to my personal product.
Sì, grazie. Então, antes de terminar aqui a palestra, eu gostaria de fazer alguns agradecimentos, farei em italiano. Allora, per finire, dottor Filippo, a nome del direttore della Scuola Superiore del Pubblico Ministero, ringrazio la disponibilità, la chiarezza dell'intervento, della qualità di tutte le informazioni e elementi e soprattutto di questa disponibilità e informazioni su questo libro che sarà molto utile a tutti quanti che lavorano con questo argomento. Devo dire che noi abbiamo per questo seminario circa 300 iscritti e durante l'intervento, secondo i tecnici, noi abbiamo avuto circa 400-500 persone che hanno potuto cogliere tutte le sue informazioni. La ringrazio della cortesia, della disponibilità e noi in Brasile siamo qui a disposizione per tutti i tipi di collaborazioni per il combate alla corruzione e al reato organizzato e tutto questo tipo di organizzazioni.
Io vi ringrazio.
Sì.
Io vi ringrazio e voglio anche dirvi che ho informato di questa mia conferenza anche il collega presidente di Eurojust. Il collegio di Eurojust è stato informato di questo collegamento internazionale e quindi io vi porto anche i saluti di tutta l'agenzia che io sono qui oggi a rappresentare, e noi abbiamo bisogno della vostra collaborazione anche per il futuro e quindi io certamente raccolgo questa offerta di disponibilità che ricambio anche da parte nostra una grande disponibilità a continuare la collaborazione operativa ma anche la collaborazione scientifica come abbiamo fatto oggi. Grazie molto signor direttore.
Sì, noi che la ringraziamo e dal messaggio che arrivano a noi Il seminario, l'intervento è stato molto gradito. Grazie. Então, está encerrada a palestra. Muito obrigado àqueles que nos assistiram.